Hello, I'm attorney Joseph Attello of the Batello Law Group. Today we're going to be discussing estate planning and what is estate planning, and more specifically, what are the different legal documents that you can employ to facilitate your estate planning needs. And estate planning is essentially what you do to assure that the money you've made within your life, the assets you have acquired such as real estate and others such as financial investments, stocks, bonds, CDs, those types of things, how they are administrated at the time of your death or before your death. Plus, estate planning also refers to dealing with your health if you're in a situation where you find yourself incapacitated, or if you're at the end of your life, what types of medical treatments you wish to have, what types of medical treatments you don't wish to have, such as a do not resuscitate order. Those are what are considered estate planning. Now we will go through different forms of estate planning. I'm going to go over them briefly. Then if you want to know more about them, please keep tuned, because we will have a video and a blog on each of these subjects. Please visit our blog to this video, which will be linked in the description below, and you'll get a more in-depth analysis of what each of these types of estate planning legal documents are, what benefits they can provide to you, and also you'll also be able to, as I produce more of these videos, I'll be placing the links to them also in the bottom of the description below. The first thing is the one everyone thinks about. That is your last will and testament. So what is a last will and testament? A last will and testament is essentially you putting onto a legal document which describes exactly how you are to disperse your assets, to which heirs are not to get any assets if they would have legally got assets had you not had a will, and also dealing with issues such as if you have minor children, appointing a guardian, or you can go as far as appointing a guardian for your pet. That's essentially what a will is. You put a will, then you get the will probated by the probate and family court. Well, that's where it happens in the Commonwealth of Massachusetts. And a personal representative, which most of you know as an executor, would be placed to actually administer the probate of your estate, and that person would be responsible for actually signing deeds, transferring money from one account to another, and so on and so forth. Vast majority of you know exactly what a will is, or have a decent idea. This is basically the first thing anyone thinks of when it comes to estate planning, but there is so much more to estate planning, and that's really the point of this video, to let you know the complexities of all the different ways that we can actually, as legal professionals, help you in facilitating your last wishes. The next would be a simple declaration of homestead. Now, a declaration of homestead, which requires that you have a home, you own it legally, it's also your primary residence. You can obtain in the Commonwealth of Massachusetts up to $500,000 of protection against certain creditors. Creditors are people you owe money to, that you've received a judgment in a legal proceeding, such as a lawsuit, or possibly you've settled out of court and they're trying to recoup that money however they can. A homestead could in fact protect your home up to $500,000 in the Commonwealth of Massachusetts from being taken within these legal proceedings, lawsuit, or a settlement. The next would be a healthcare proxy. A healthcare proxy is essentially who you determine to make your healthcare decisions for you in the event of your incapacitation or your end-of-life wishes. Essentially, this person would be appointed and would tell the doctors and speak to the doctors, essentially speak to the doctors for you since you're incapacitated or you're not in a position where you can actually make those choices. Let's say you have severe dementia, you have severe Alzheimer's, you might not be incapacitated, but you certainly should not be making any medical decisions. A healthcare proxy is the person you would appoint to make those decisions for you, such as a do not resuscitate order if you were to expire and you do not want the doctors to take extraordinary measures to revive you. That's one example. Putting in a feeding tube, putting you on a ventilator, these are all decisions that your healthcare proxy would inform your doctor that's your wish or your wish not to have those procedures. They basically speak to the doctor for you in your stead. The next one is a simple one. That is a HIPAA release. Now, a HIPAA release, essentially all it does is allows you or whoever you're going to appoint to be able to receive medical information from a doctor. It does not give you the ability to make any medical decisions, but in a situation, say you want one of your parents to be able to know what's going on for you, but you've established someone else as your healthcare proxy, but you want to know, you want certain family members to have access to those medical records and to be able to speak to your doctor about what's going on. With a HIPAA release, your doctor is legally able to speak to whoever you've offered this release to. They can know exactly what's going on within your medical care. This can be done if you're incapacitated, or you can have an open-ended HIPAA release, meaning that that person can always ask your doctor what your medical treatment or what your medical condition is. The next one, most of you know this, and it is a power of attorney. Now, there are different types of powers of attorney. They can be drafted as broadly as you want or as specifically as you want. A power of attorney essentially gives another person the power to act in your stead. Meaning that, let's say you for some reason were not going to be able to sign a deed or a mortgage on a particular day because you're going to be out of the country. That's essentially what a power of attorney is. But in the realm of estate planning, a power of attorney can give people those rights to deal with your particular situation, depending on if you're incapacitated or even if you're not incapacitated. If you do not have the mental capability of making informed choices on whatever it is, generally financial and dealing with your property, your estate, your bank accounts, and generally things of that nature. You can also make what is called a durable power of attorney. Now, a durable power of attorney allows you, once you've become incapacitated and can no longer speak for yourself, it'll give the person you've appointed as your power of attorney all of the powers to make financial decisions, execute contracts, execute loans, execute deeds. Essentially, they're able to do what you can do in case that you are not able to perform those functions. Now, there is a difference between a power of attorney and a durable power of attorney, and that's essentially the way it's drafted and how broadly or narrowly you place them. A durable power of attorney is once you've lost the capacity to make these choices up for yourself or to facilitate any of the execution of a numerous legal documents. That would be a durable power of attorney. A power of attorney allows someone to do that prior to you being incapacitated. Now, the next would be trusts. Now, there are many forms of trusts that are able to perform a number of different things for your estate, depending on the type of trust. But essentially, a trust forms a separate legal entity akin to an LLC or a corporation, which is technically, in the eyes of the law, a person. They use the word entity, but it's another entity. But just for a lack of a better term, for those of you who don't like that term, just consider it another person. That entity gets its own tax ID number and also is able to own real estate, assets, manage money accounts, CDs, pretty much anything that you own, you could transfer and put it into a trust. Now, we're definitely going to have to do a very long and extensive video on trust, possibly even several different videos considering the different kinds of trusts. I'll give you a few examples. There are revocable trusts, there are irrevocable trusts, there are special needs trusts, and there are spendthrift trusts. There are also other trusts such as nominee or real estate trusts, but essentially the most important ones are the first four. The revocable trust is basically a trust that you put your money into, your real estate into, your assets into, and a trustee that you appoint, many times yourself in this situation, will facilitate the assets that you've placed in the trust for the beneficiary. In many cases, it's also yourself or other beneficiaries such as family, friends, loved ones, things of that nature. The reason for trust is also to protect your assets from creditors. Since the assets are located in a trust, that means technically, even if you're the trustee or the beneficiary, you don't legally own the property. It's separate and apart from you. This does not protect you in every and all situations. Those particular situations are for another video. But what you need to know now is a trust is formed. It's its own legal entity. You place your assets, real estate, money, CDs, stocks, bonds, into that trust, which separates your assets from yourself. So if you're sued, they cannot take your assets because technically they don't even belong to you. That's a revocable trust. An irrevocable trust is very similar to a revocable trust, except it's irrevocable, meaning that once you establish that trust, you cannot get rid of it. A revocable trust, you can end it at any time and transfer all the property back to yourself. A revocable trust does not afford you that opportunity. Once you've established an irrevocable trust, whatever the language in that irrevocable trust has, you're going to have to live with that. But many people say, but Joe, why would I want to do that? Why would I want the option? Well, there are certain situations where an irrevocable trust actually provides you more protection than a revocable trust. One right off the top of my head would be dealing with Medicare. So if you have a bunch of assets, and more particularly real estate in this situation, and at the end of your life, you go into, say, hospice care or spend several weeks or months in the hospital, once you finally pass away, Medicare that was paying for those debts are actually going to go after your estate, and they're going to want to sell your house and recoup the money of your hospital visits or your medical expenses, which will leave your family with nothing in the vast majority of cases. Because how expensive medical care is these days, it's extremely costly at the end of your life, especially if you're remaining in a hospital. An irrevocable trust can protect your estate from the government taking your assets due to the fact that Medicare paid out. There's also a spendthrift trust, which is basically a good example is if you had a child who you know is not going to be good with money, so instead of leaving the money to your child or assets to your child in a will, you put it in a trust, and the trust allows a trustee to give that child funds to pay monthly bills or whatever you want, however you want. Basically, whatever you want to do, you can put into a trust, and the trustee has to follow that. I would say that a trust is by far the best legal vessel within all of estate planning, because the main thing is it allows you to put all your assets into the trust prior to you passing away, which one, keeps your family to having to go to a lawyer and file your will in probate court and probate your estate, and then possibly also have tax ramifications. This takes your property while you're still alive, place it in a trust, or you can also establish a trust that in your will all of your assets go into the trust at your death. Generally, we tell people to put their assets in a trust prior to that. And in fact, a trust is something that we're going to advise all our clients to do, even if they just have one single piece of real estate. But once again, more for that in video specifically on trusts. The next form of estate planning is what's called a life estate deed. A life estate deed is exactly similar to a quitclaim deed, although the only difference is you're transferring the property from yourself to someone else, could be spouse, child, loved one, third party, whatever, but for your life, you get the benefit of that property. Meaning, if it's your residence, you get to live there for your entire life. And once you pass away, that property goes directly to the people that you've given the life estate deed to. Or if you have rental property and you take a life estate deed on that rental property, you don't live there, but you're going to still get the money from that property throughout your entire lifetime until you die. You get to manage it, do whatever you want to it until you pass away, and on your passing, it automatically goes to whoever you've named on the deed to receive that property. The main reason for this is to avoid probate, and also this is a second way to avoid having the government seize your property due to health care expenses at the end of your life, such as hospice, extended stays at a hospital. As long as you file within the prerequisite time, and different states have different time periods. It's usually a number of years. You can't do this right before your death. Same thing with a revocable trust. Can't do it right before your death. You have to do this a number of years depending on the state you live in. The next form of estate planning is a guardianship. Now, a guardianship are for minors or adults that are not able to deal with their financial situations. It's mostly for minors, because unless you're actually making decisions up for the adult that is not capable of making up these decisions for themselves, and it's only financial, that would be a conservatorship. We'll actually discuss that later. But essentially, a guardianship allows one party, a person that you appoint as the guardian, to take care of a minor or an adult that does not have the mental facilities to properly deal with either financial issues or housing issues or medical issues. Any of these things that essentially a parent would do for a child, a guardian would do within a guardianship. Now, the next thing is a guardianship proxy. This is very simple. It's simply prior to your passing, you're already choosing who would be the guardian for either a minor child or an adult that requires a guardian. The next thing would be the administration of the estate through probate. That's essentially, regardless if there's a will or not a will, you're going to have to probate that person's estate. The administration of estate generally refers to intestate succession, meaning there is no will. If there's no will, you still need to go to probate court, and you have to have an administrator of the estate appointed by the court, and that administrator, which is essentially an executor to a will, but there's no will in place, so it's an administrator of the estate, and they do all the functions of an executor. They get to sell property, they're the ones that divide assets, they're the ones that establish a checking account for the estate where all the monetary assets of the estate are liquidated into, or essentially, if you've got CDs and you just want to liquidate them, and then you have money, that money will be put in an account that's established for the estate. The administrator of the estate would then divide that by the rule of law. This differs from the probate of a will, because in the probate of a will, as long as the will is found to be valid, the executor in Massachusetts, they're called personal representatives. They're the exact same thing. The executor or executrix will in fact be the one who is signing the deeds, writing out checks to disperse money, or facilitating any documentation required to transfer assets or property from the decedent's estate to the person or heir who is going to receive them after the passing. And finally, conservatorship. This is very much like a guardianship, although a conservatorship only deals with financial issues. Unlike a guardianship, which can also deal with making choices for a minor or an adult that does not have the capacity to make those choices up for them, such as medical decisions or financial decisions. A conservatorship is only pertaining to financial matters, and the conservatorship can be established as specifically as possible or as broadly as possible, meaning that you can either have the conservator deal with this person and make all the financial decisions for them, well, pertaining to the money that you're leaving them, or it can also be set up where they can only make certain financial decisions for them, where the normal day-to-day stuff is left up to the individual, but certain decisions are always left up to the conservator. So that's essentially the different legal vessels that are able to be employed in estate planning. There are more. There are other financial legal documents and processes that can be employed, but the ones we've outlined today in this video are the essentials. These are the ones you need to understand the most of. Most importantly, these are extremely difficult and very law intensive. It's not simply filling out a form and checking off boxes. So as far as this type of law, you certainly do want to find an experienced estate planning attorney that is able to guide you through the different options you have for your particular financial situation, your particular set of assets, your real estate needs. Make sure you find a competent and experienced estate planning attorney that'll be able to give you all of these options. Do not seek the advice of someone who only handles several of these, because there may be options that they do not deal with that will actually be more suited to your particular situation. This is, once again, Attorney Joseph Attello for the Batello Law Group, and this has been Estate Planning. Make sure you watch our other videos on this subject, where we will be going over each and every topic that we covered in this video. Thank you and have a good day. If you enjoyed this video, please press the like button and subscribe to our channel. Also, click the notification bell to get future videos that we'll be putting out. And please share our content on social media.